we're going to go to the fact patterns because, let's see if I can get you to the fact patterns. And they're meant to be very, very short. Do you guys have the fact patterns in your, no? Okay, so I'm going to give you a fact pattern, and we'll try to develop the fact pattern. And I'm going to be asking a number of questions because I'm not real good at basically lecturing all day long, and nor do I want to bore you guys with things. So what we're going to do is we're going to talk about a situation, and then we're going to try to develop it. Easy Hurt, 52-year-old attorney, driving automobile north on Main Street, was rear-ended by not-looking defendant. As a result, big accident. Plaintiff was taken by ambulance to the emergency room of fictional hospital. There he had problems with his back. Okay. So, I'm just going to go around the horn. Your name? Carrie, what's the first thing you want to know, Carrie?
If there's any measurable amount of damages that he has suffered.
Oh, injuries. And what is your name? Tiffany? Could you do us a favor and can you come up here and we're going to just write down a list of things? I'm sorry. I always sat in the front of the class too, and I used to get called, so. You okay?
Yeah.
Okay, just 1, 2, 3, 4. So we're talking about injuries. Let's talk about what kind of documents first do you want before you really develop your case. So with injuries, how would you want to develop the injuries? Name? Kevin. How would you want to develop the injury issue? Medical bills. So where do we get the medical bills from? From the hospital. So
Medical bills?
injuries, you can put injuries up here, okay? I should have gotten somebody a little taller. I'm sorry. Okay, so hospital. You can put down hospital. And besides the hospital, where would you go? Name? Igor. Where would you go? Well, you want to find out what your injuries are. And your senior attorney said, you're not getting a salary unless you come up with an idea of how we're going to make this case a big case. Igor, your salary is on the line. Come up with something. Where are you going to get your...
Interview with the client.
Okay, interview with the client.
Independent medical.
Okay, from whom?
Someone other than that hospital.
Which would be?
A medical expert.
A doctor. Okay, doctor. Now, usually or typically what will happen in these cases, okay, basically a doctor will be an internist. They'll see you in there, or it'll be an emergency room doctor, and he'll look you over and he says, this is what my granddaughter does. And then what will happen is basically he'll say, I think you should go to an orthopedist. Your arm doesn't look so good. It's somewhat crooked around here, okay? So who are they going to refer you to? They'll refer you to probably an orthopedist, right? Okay, so we get an orthopedist. So we're going to want to see the doctor's reports, the expert doctor's reports, right? And what else are we going to see? What else are we going to want to see? What's your name? Nick. What else are you going to want to see? What are the doctors going to do? And every doctor does this, X-rays. X-rays, absolutely. And besides X-rays, what are they going to ask you for? If it's a fracture, it's X-rays. If it's the back or something, what do you think they're going to ask you for? MRIs. Good going. The other day I ended up in the hospital and I had some what's known as kidney stones. They brought me to, and what they do for that is they do these scans. So you're going to ask for a scan too. It's amazing what happens with these scans. What they do is they scan you. They put you in this little tunnel and they scan it, and they can actually show a three-dimensional thing. So they just, it's absolutely amazing. And they were able to see this 2-millimeter stone. So medicine has really, really developed since I've been practicing law. You're doing real good. Thank you. Okay, so we're figuring out basically what kind of paperwork we need concerning basically injuries, right? What else are you going to want to know about injuries? What's your name? What is it? Mercedes. Hi, Mercedes. How you doing? What are you going to want to know also about injuries besides the doctor's reports and the medical bills and the hospital reports and the bills and the MRIs and the scans? What else are you going to want to know? Well, what kind of loss? Go ahead. Work. Okay. Example. If you don't mind me giving you examples, I'm going to give you examples. We had a client who fell from the second floor. What happened was he kind of leaned on the railing, and the railing really wasn't so well supported, and he fell down, and actually him and his friend fell down. He broke or shattered his wrist in approximately, I think, 6 different places. There are only 9 bones in the wrist. And he was a cook. And when we got the economist involved, the economist came out with $1.5 million loss. I'm saying, wow, I got a great case. He's not going to be able to work because he can't lift up anything in the one wrist, and he's going to have difficulty cooking. And I'm saying to myself, I have it made. And lo and behold, he comes in after 2 years. And I asked him, how you doing? He says, I'm doing fine. I said, are you working? He says, yeah, they hired me back. Marriott Hotels hired me back. And I said, that's great. Are you able to work? How will you be able to, he says, oh, don't worry about it. Instead of making $80,000 a year, I'm making $120,000 a year, and I'm teaching cooks how to cook. And with that one sentence, the case went from $1.5 million down a bit. We ended up settling the case out for about $600,000, which was a nice hit. But I said, I don't want to try this case at this point in time. They already made us an offer of $600,000. Take the money and run. You got to know when to. That's one of the things you really have to do. You have to evaluate your case, and you have to know when to run. So missed time from work is important, or work is important. And the record you would want to know, basically, at missed time would be your work records, obviously, and your attendance records. Okay? So we got some of the injuries. What other injuries would there be with reference to that? You got your doctors coming in and talking about it. What else? Yes?
Any pre-existing stuff?
Pre-existing stuff. That would be on the injuries, but pre-existing stuff. You want to see past records, past medical records. Example. I have an old soldier who had some problems and has retired. He, really good guy, friend of mine, has had about 3 or 4 accidents in the past. And now his claim is, well, even though I was really having difficulty playing golf, I can't play golf now. And even though I was walking with a cane, I have to walk with a walker now. And even though I've had all this medical problems, and part of it is because of my size, he's extremely big and weighs a lot, which has a factor. I can't do that. And the doctor comes back and says, basically, it's merely an exacerbation of a pre-existing condition. In other words, the case has been made somewhat worse. And I have a problem with it, because all I have is an exacerbation of a pre-existing condition, and he's saying it's affected his whole life. And he's 65, actually, I think he's 67 now. So the question then becomes, how do I maximize the cost? And I know the former speaker here was talking about summary trials, and that may be one of the ways I'm going to do it, because he's being treated down in Georgia, and if I'm going to bring a doctor up to New York, what do you think is going to happen?
Price tag.
Huh?
Price tag.
Yeah, it's not going to be cost effective. What's going to happen is the doctor, when I first started practicing law in personal injury, the amounts of money we were paying doctors was about $2,500 for a testimony. It went up to $5,000. It's now $10,000, $15,000, $20,000. And I'm saying I have an exacerbation of a pre-existing condition. I have a problem. One other case I'll just briefly talk about is I had a lady who had MS. And she had an accident, rear-end collision. We had liability cold. Absolutely clear liability. She had MS. And what I did was, and if you take a look, am I going to be able to get this on? Yeah. If you take a look, let me see if I have it. Here you go, the experience transformer. I have a problem, and I use this experience transformer to decide how am I going to sell this case to the insurance company. The insurance company says it's an exacerbation of a pre-existing condition. We don't even know whether you make serious injury. We're not even certain with it, because where's the injury? She's already been retired. She has MS. She's not working, so I don't have the argument of work. I don't have the lost earnings or anything else like that. Where am I going? And as I wrote out what helps or what works and what doesn't work, I came up with the argument. Humpty Dumpty sat on the wall, Humpty Dumpty had a great fall, Humpty Dumpty couldn't do no more. And my argument was basically, hey, you take the client as is. Defendant, you have to take the client as is, and as a practical matter, she fell. And you can't put the egg back together again. So we ended up getting, the offer was originally, I guess, about $10,000. We were able to get $50,000 on it with that argument. But it was a tough case, it really was. What other issues are you going to want to know about? And you know what? I'm going to let you sit down, and I'm going to, what's your name? David, come on up. Jason, I'm sorry. I'm Gary, okay? Jason, your job now. Okay? And what other issues are you going to want to know about? Your name?
Marlene,
Hi, Marlene.
likelihood of future medical issues?
Okay, so the medical issues will be, and you can put this up for injuries, past, present, and future. Okay, we'll knock that out that way. It's good issue. And how much is the extra cost going to be later on? What other issues are we going to know about? Nobody's talked about.
Personal factors, like if the person is married or has kids, so you can make a loss of services claim or a loss of consortium.
Good. Loss of services, and we'll consider that as part of loss of consortium, okay? So if somebody is basically providing for the wife and children, and they no longer have any, he can't work, the individual can't work. This is Easy Hurt. He's a 52-year-old attorney, and he can't work. Then the wife and or the children may have an additional cause of action. Typically or normally, unless it's a really serious injury, I usually don't bring them in because it gets lost in the shuffle. However, there are some times where, you know, a fractured wrist where it's not that it's life-threatening, but it's work-related, and it's threatening to his whole existence of working and what he's been trained to do. I mean, this guy was a very, very fine cook. You can argue that. What other things are you going to look towards? Did I get you?
You have not.
What's your name?
Brian,
Hey, Brian.
we still talking about injuries here?
What?
Still talking about injuries and
We don't talk. I want to know other things. Nobody's. We've kind of gone a lot about injuries, but what about the other factors?
right, so this was a car accident, correct? I would want to know what the conditions were like on the road at that time.
Okay, but where would you go first? Where would you go first to find out how the accident happened? Besides talking.
The police reports.
Yeah, police report. Need the police report. Absolutely. We're going up this way. How you doing? Name? Jessica. What's the next thing you want to know about the police report? Well, what are you going to look at when you're looking at the police report?
How the accident happened.
Okay. And we know basically, because I've given you those factors, that it's a rear end collision. Okay? And what else would you want to know? Your name? Hi, Christina.
I'd like to know whether there was maybe someone else involved, so that not be maybe this guy can just stop because someone else interfered with him. If it was really related to what he did.
Okay. That someone else, that third party, what is he considered? Or what could he be considered? Huh? Additional defense. Well, I'm looking at it in somebody else's. First, take the plaintiff's call. What else could he be if you're doing this stuff? He could be a possible another plaintiff if you want. And instead of getting X, you may be able to get 2X on the case. Right? Next person. Hi, Mike. What else are you going to look at? Insurance company. Absolutely. And why do you want to know about the insurance company as plaintiff? What do you have to fill out? Anybody know what they have to fill out? Please, come on, help. Okay, the plaintiff has to fill out an MV 104. And what else is he going to have to fill out if he wants somebody to pay for it? Okay, and that would be a no-fault claim, right? In New York State, we have what's known as no fault under Article 52, and you want to fill out a no-fault claim. And do you know what you're entitled to under no fault? And I'm going to give you some practical advice at this point in time, if I can. No fault, you're entitled to, if the injury is bad enough, you're entitled to $2,000 a month for up to 3 years. So if you can't work for 3 years, you're entitled to $2,000 a month for 3 years, a total of $36,000. In addition, you're entitled to $25 a day for all reasonable expenses for up to 1 year after the accident. And everything can't exceed $50,000. Now, other states have different things involved. Other states decide different ways of doing it. And when I have a case, we're just finishing a case now where one of the attorneys from Massachusetts called me up and said, Garrett, can you help us? We're not getting a lot of money on this case. Can you see if you... And we were resolving it, and his insurance company from Massachusetts said basically, we have a lien, we want our money back. And I said, well, You can want your money back from Massachusetts insurance company, but you're not getting it. And he said, what do you mean? I said, you got to look at New York State law. My client is entitled, since he's in New York State, to no-fault benefits in New York State. And therefore, you don't have a lien under those conditions. So that was kind of interesting. The other issue would be if it's over $50,000, and I'm just going to talk briefly about insurance. Is anybody involved in insurance law here? All the way up there, how you doing? What's your name? Hi, Marielle. What kind of insurance would you tell everyone here to get? Because I'm going to advise you on what kind of insurance you should get.
Well, definitely get a life insurance policy, but I mean, everything in New York, you get to the vehicular collision or accident from your no-fault, so you definitely need automobile insurance.
Okay, and we're going to talk about what kind of automobile insurance. And all I want to do is talk about automobile insurance. What kind of insurance would you get? Not what company. We're not looking to help out but what would you want? Everybody knows basically $25,000 is the minimum policy you could get?
I would get additional.
Additional, how much? Okay, as much as you can afford. What's your name? Matt.
100, 300.
At least 100, 300. Why?
Because it's more of a policy, it gives an attorney more inclination to only go for the policy. If you have, the more money you have in your pockets, the more likely they are to personally go after you over the 25 limit. But if you have 100, it gives you more wiggle room.
And there's another thing too. You probably, if you have 100, 300, you probably could get an umbrella policy. And I would strongly urge you basically to get an umbrella policy. You can write this down. Policy, umbrella, okay? And you want an umbrella policy because the umbrella policy is probably going to cost you $50, $100 or something like that. And this way, you're insuring everybody who's going to go up against you up to probably $1 million.
Another thing too is, if they only have a 25 policy on the other side, you can go for excess of 75.
What kind of insurance would that be? Because that was the next, huh? Yes, some policy is what's known under. I believe it's under section 34 of the insurance law. And you want the sum policy. That's really important too. Okay, and the sum policy says, let's assume somebody hits you and they only have a $25,000 policy. Okay, but you have $100,000 on the policy. What does that entitle you if you have a sum policy? I'm going to ask you. Okay, let's assume you only have, somebody hits you, you have a 100 policy, but he only has $25,000 policy. What can you do?
You gotta be able to get over his 25 policy, and then you can go for another 75 on your own to complete the 100.
So if you're badly hurt, at least you have that. And my understanding is you probably could get some policy up to 300, maybe depending upon the company, maybe up to 500,000. And you may want to consider that. Okay, so we got the sum policy. I'm glad we hit that one. What other things are we going to want done on this case? We have the police report, and we have the no-fault application. Oh, no-fault application has to be supplied within a short period of time. So you have an accident, you got to report this right away to your insurance company. And what we do in our letters concerning some policies is we indicate in our letters basically saying that, please note, we're putting you on notice of our claim or possible claim for some. We word it a different way, but we basically advise them that if in fact the policy is less, we're planning on going after this sum. And we give a copy of the police accident report so they have all the information concerning that. So the insurance company can't deny that argument, because they will if you don't at least give the proper notification on that. What other things are we going to want to know about these issues? Jason, you have a thought on this? Any other?
Just in general, want to know the other party's entirely at fault, or my client had somewhat the responsibility in the accident? Try to get an idea of
What the other party has.
ask for damages.
What you can do is you can send a letter out to the Department of Motor Vehicles asking for their MV 104 report. Okay? And you can do it that way. What's worth 1,000 words? Pictures. So what kind of pictures are we going to? You can put that right over there. Injuries. What? Okay. I usually don't do weather unless it's a slip or trip and fall, and I'll look at the area and we'll try to show pictures of. Sometimes it's there, sometimes it's not. Sometimes you have situations where there's lots of snow banks all over the place, and you can see the snow and you can see the ice and everything. And if you can get pictures right away, that's always worth 1,000 words. Okay? So we want to do the scene of the accident. We want to see the injuries. Sometimes the injuries are, extensive. If you have an injury across the forehead, I had a lady who was bitten in the face, and we take the picture right away so they could see what it looked like. I have another lady that was bitten on the breast, and she was her mother died of cancer, breast cancer, and that was somewhat helpful in our argument, at least. So pictures are really helpful. What other pictures would you want? Well, you have the scene of the accident, you have the injuries. Vehicles, exactly. Thank you. What's your name? Perfect. We want pictures of both the plaintiffs as well as the defendants' vehicles, because that would be really very helpful. And with every case we get, okay, when we take a case in, we go through those particular processes, those two processes. In any case we take, what do you think we get from the client? Two things, automatically. What do you want from the client? And this isn't working. Jose. I don't know what happened, but what do you think you want from... it's not working now. What do you think you're going to want? Authorization. You have to have authorizations. Usually what we'll do, and I'm going to spare you some time if in fact you can, and what's really important is, on it you could say all Xerox copies, all facsimiles or what have you will be considered as originals. And if you put that in, or if you give, we'll sometimes take a power of attorney for all those things, and we'll be able to send out a bunch of authorizations to obtain the hospital records, the doctor's reports, whether it's a neurologist or an orthopedic or something else, we'll ask for them. We'll get the x-rays, the MRIs, and the scans. We'll ask the employer for all his records, and you need the authorizations. But before you get the authorizations, what do you have to have? You have to have authority. And what gives you the authority to act that way? Retainer. I was going to go to the retainer, and I was going to kind of give you a hint of what I was talking about, but I can't go because computers are sometimes great, and sometimes you can use them, sometimes you can't. But you want a retainer. When I first started practicing law, the retainers were kind of small. If you take a look, that's the form retainer that I use usually, so I'm giving it to you that way. The appellate division recently came out with a new retainer where they give you two options. I usually go with the first option. That's the option I've always used. That's the option I want to use. Here, I'll take it from you now, okay? Thank you. Appreciate it, Jason. Okay, so if you get 10 on the first option, and you spent out 1, you're entitled to this 1, and then you're entitled to a third of whatever the net recovery is. Okay? So you're entitled to 6-4 split. If it was 199, you'd be entitled to a 34-66 split. If it was one whatever amount. Everybody understands that? Simple. Okay? You got it? Okay. The second option is a little different. You got to outlay the money. Quite frankly, if it's a good case, we outlay the money anyhow. Please don't tell my clients that. But we outlay the money because if it's a good client, we hope it's money in the bank, and we want to deal with it that way. That third person in the car, in the plaintiff's car, what else are you going to want? Yeah, you're going to want to witness a statement from any passenger in the car, in your client's car, and if you could get the defendant's witnesses or the witnesses on the scene, that's always helpful. In the police accident report, you'll see there's a box, okay? I don't have the police accident report, but what's your name? Yeah. In the police accident report, what else are you going to look towards? You have any idea? I'll give it to you, okay?
Any notations if anyone got a ticket or
Yeah, violations, exactly. So if somebody got a ticket for an 1110A, I want to know about that because that would be basically violating a traffic control device. If anybody got a ticket, and I'll give you some ideas of what I'm going to be looking for. What you want to do is you want to look at what's known as the PJI. Does anybody know what the PJI is? Because that's the first place you probably should look towards. Don't all answer at once. Anybody know what PJI is? You know what PJI is, right?
jury instructions.
Pattern jury instructions. And we look at that because we want to know what we have to prove on the breach of duty. We want to know where the breach of duty is. If it's a rear-end collision, quite frankly, we have a form motion that goes out, and we usually get liability on that. But there are other issues that we may be considering, such as speed. If somebody was speeding in 1180 and it's noted there for the violation 1180, we know basically that there's an issue there, and we'll ask a bunch of questions concerning that. We may want to know whether or not they were in the wrong lane. I had a client yesterday call me up and say, "Yeah, police are here, and I'm not certain what to do, but it's such a BS stop." So I said, "What's wrong, Christine?" He says, "Yeah, I was just driving, honestly, and the cop just stopped me." And then a few expletives, and she says, I told her, "Look, Christine, just calm down, take it easy. Relax. Do not argue with the cop at all." I said, "I can argue with him. You don't argue with him." Nice and easy, smile. If you ever get caught with a cop, my suggestion, I'm giving you another secret, okay, is when you get stopped by an officer, put your hands on the wheel. Does anybody understand why you're putting your hands on the wheel? Why?
So you're not showing that you're threatened.
Perfect. And then the officer will tell you, pull down the window. You basically, you open up the window and he'll talk to you. He says, "Do you know what you did wrong?" And the easy answer that I always have is, and you can quote me if you want, just don't tell him I said so, is basically, "Officer, if I did something wrong, I'm sorry." It's a real easy way of giving deference to the officer and telling the officer you don't want to argue with him, you don't want to fight with him, you're not certain why he's stopping you, and you're not admitting to anything. Because I don't want to admit to anything either. And that kind of controls things. Let me give you some other issues. A wrong lane, backing into traffic when you're coming out of a parking lot or a parking space. If you're not watching where you're going and you hit somebody, You're responsible. Yielding to the police or yielding to any emergency place. You want to make sure that you don't violate that issue. Passing on the right. You ever pass on the right while you're on the thruway? Well, you got to be careful on that because you're not supposed to pass on the right. Okay? Unlicensed, a 509, which is an unlicensed operation, or a 511 where driving while revoked. Those could have an impact on the case. The violation, however, you have to admit to it, and it has to have caused the accident, or else it may not be able, it probably will not go in as evidence. So there has to be an admission, and it has to have caused the accident. Traffic control device we've already talked about, stop sign or yield, tailgating, skidding, it can be an evidence, bad brakes, stopping or yielding. You're on the phone texting. That comes a long way, and I'll tell you what we've done in the past. We've asked for, we'll ask for sometimes the telephone records if we can get them and find out whether or not somebody was texting, if it's a big enough case. And a seatbelt. You got to be careful with the seatbelt. So those are issues that may come into play when you're talking about breach of duty. How are we doing?
What are we looking for?
I was looking to just get in there. That's all.
Perfect. You got it.
I'm good. Okay. Now, you got your signed retainer agreement, and the question then becomes, you're in court, or you're going to be in court, or you're going to prepare a summons and complaint. What issues are you going to want to address? And if you could do me a big favor, and I'm going to put you up here if you can. I just have to find, where did I put it? Oh, here it is. Yeah, do that. You got to be resilient and inventive, a little creative. What other things are we going to want to look at in reference to a case? I remember Professor Siegel telling me way back when I went to Albany Law, and I remember him in, civil practice telling me. Did anybody hear of Professor Siegel? Anybody read his book, CPLR? No? Really, really profound professor. Minored him in Albany. I remember him talking about it and says, residency is kind of important. Anybody have any idea why residency would be important? What's your name? Excuse me. What's your name? Charles. Charles. Why would residency be important? Yeah, why would residency be important? Well, jurisdiction, first of all, but yeah, what else?
More likely to win a jury in Brooklyn than you are in Nassau.
Yeah. It's amazing. We have a case now in Poughkeepsie. My client is a builder, a contractor in Poughkeepsie, and he claims my client owes him money. My client claims he owes us money. And what do? I say, I want to be in Rockland County because that's where I'm located. I'm in Rockland and Westchester. So I say, I want to be in Rockland County. Rockland County is easier for me to deal with. I'm bringing him down here. It's going to cost him a whole lot more. If I have to go up, it's going to cost my client a whole lot more. So what do? I bring him in Rockland County. If it's a personal injury case, I want the case in the Bronx. I don't want the case necessarily in Queens. I don't want the case in Suffolk. And quite frankly, I prefer the case not in Rockland. Please don't quote me again. But I want the case in the Bronx and probably Brooklyn because, why because? What do you think the reason you would want it in the Bronx or, what's your name? Yeah. Okay. He saved you, okay? You owe him one.
Higher payouts, they slam insurance companies more.
Yeah, yeah. And I'm not a big lover of insurance companies. No offense up there. I just, good. And if I can hit the insurance companies, they get away with enough. I mean, I have enough clients at this point in time where they say, no, we're denying payments here, we're denying payments there, we're denying no-fault payments or what have you. Well, if I can hit them in the Bronx or Brooklyn, which are better payouts, I'm going to do it that way. And I'm going to try to push it that way. So the first thing I'll look before I start preparing my summons and complaint is basically where the residencies are. You know about the residency statutes and everything. Yes? No? Maybe? Okay. If somebody lives in the Bronx or somebody lives in Brooklyn, sue them there if you're doing personal injury. I'm not saying any other type of case, but that's what I'm suggesting. Okay. What other issues would you look towards while you're preparing a summons and complaint? You're going to prepare your complaint this way with basically my client should be free from bodily harm. He breached his duty by speeding and by rear-ending our client in the car, and it was a really bad rear-end collision. And as a result, my client suffered injuries. And there's a special clause under the Bill of Particulars or what have you. You're not supposed to put the jurisdictional amount in anymore. We used to say $1 million, $2 million. I used to even say up to $10 million. Now you don't put that in. You just say it's the jurisdictional amount. But we would say basically the person suffered and met the threshold of 5102 of the insurance law. And that would be your summons and complaint. And you'd have basically you've made your decision where the Supreme Court, what Supreme Court you're going into. Do not go into small claims court. Small claims court, don't do because it's going to cost too much to process. Okay, and you're only entitled to up to $5,000 in city, and you're only entitled up to $3,000 outside the city under Section 18 of the Justice Court Act. So you don't want to do that because the doctor will cost you a whole lot more than the case, and you're not being basically cost effective. What other issues do you want to do? When you got all this information, what are you going to do with this information? How you doing? What's your name? Ty? George. Hi, George. Hi. What are you going to do with the information before you start the summons and complaint?
Before you start drafting a complaint.
Yeah, what are you going to do? Okay, so you're going to send a specials letter out, or demand letter out, whatever you want to call it. Okay, and you're going to basically say, what I usually do is police accident report. As a result, there were certain injuries. As a result, my client wasn't able to work. Here are copies of the witnesses. Here are copies of the photos. And you develop that pattern. And you have a case that you're presenting to the insurance company, and you want to talk to them. What is going to basically decide whether you're going to put the case into suit or not put the case into suit? You're not one back here, because I haven't talked to you. How you doing?
So, I mean, in this situation, after you've sent the demand letter, what's going to determine it?
Yeah, what are you going to do with the insurance company? What are you going to say to the insurance company? What are you going to do? How are you going to negotiate it? Hey, your boss is counting on you now, and your client's counting on you. What are you going to do?
Lay out the case.
You're going to lay out the case.
Make a demand for whatever you believe the damages are worth.
Okay.
Based on the policy.
Okay. Nice and easy, soft. You don't have to go with the big guns at that point in time. As far as I'm concerned, if you could put both parties, usually I'm trying to say, hey, insurance company, work with me and I'll work with you. Let's get this case settled before we put it into suit so all sorts of expenses don't have to be expended, right? You want to maximize the result if you can. If the case is worth $100,000, how you doing?
Good.
If the case is worth $100,000, what are you going to do when you talk to the carrier?
Send a settlement offer out?
Okay, you send the settlement demand out, and and he gets on the phone and he says, "What do you want?" You could say you want more, but how are you going to cost effectively deal with it?
You could ask them for their offer first. Tell them you're gonna save them something on policy.
Yeah, I usually do that. You know that it's going to cost you probably $10,000 for a doctor, right? We know that. So if you say, look, if you settle out now and I don't have to pay the doctor, et cetera, we'll take $95,000 on it if the policy's that. Or if the policy's $25,000, you tell them, look, I need the $25,000 because back end I have my supplemental policy and I want the money that I'm entitled to on my policy. So you can play it out both ways. You can kind of move it around that way, okay? Yes?
I have a question.
Sure.
At this point, do these types of cases go to arbitration or mediation or not? Because I do employment law and 90% of them are settled at the EEOC in mediation.
Okay.
So,
The insurance company and plaintiff's attorney can agree, basically, to send it out to either mediation or arbitration. We usually deal with NAM or some other JAMS or some other companies that we deal with. However, you can't force anybody to go into arbitration, and there's no agreement to go into arbitration. Okay, so you can't do that. So if you can convince the insurance company to deal with it, example, I have that big individual that was rear-ended and says basically the accident caused all his injuries, and it really didn't. And I've already told the insurance company, I got to keep my credibility. My credibility is most important when I'm dealing with the insurance company. And I told him, I said, look, I can't blame, but my client feels that this and this and this, and he believes that he's entitled to a humongous amount of money because he can't go back to work. He was a real estate agent, can't go back to work anymore, and he's having all sorts of difficulty. He has to walk with a walker and everything. What do you want to do? And we're in the process of discussing whether or not we're going to go into arbitration, maybe summary trial or something to that effect. And quite frankly, my client's doctors are in Georgia, so I don't want to bring them up and pay for a day or two in New York. Huh?
you can do video conference.
We could do a video conference, but I'm not thrilled about that either. The jury isn't going to be thrilled about that either. They're going to say basically, if you felt your case was so good, why didn't you bring the doctors up? And that's kind of what I would argue, you know? So that's the situation. Now, with reference to doctors, I know we haven't touched this. Yeah. With reference to doctors and any medical providers, thanks a lot again. Any medical providers, anybody have an idea of what the doctors do when they treat you? We all, and this is something, go ahead.
They have certain codes they have to put in for different types of treatments with different price lists.
So when you go into the office, what do they usually do when you see the doctor?
They ask for your insurance.
They ask for your insurance, and then what do? They usually have you sign some things, and then they have you fill out some things. What are you filling out?
The HIPAA paperwork.
You're filling out the HIPAA and usually a history. They want to know a history. They want to know what kind of medicine you're using, et cetera, et cetera. So you want to know, and you want to get all the records, notes that the doctors have made you sign, because perhaps maybe in the insurance company is looking at, did she ever or did he ever have a prior accident? Okay, and sometimes that hurts. Case in point, I had a case, first case that Judge Nelson did in Rockland County. Judge Nelson was a great guy, is a great guy. And we start the trial. I asked my client, you ever have any other prior problems? No, Gary, never. 15 times, never. And I'm saying, something's wrong about this case. The insurance company isn't coming up with anything. We go through the liability aspect, we win. We now are on the injuries aspect, and they're still trying the case. And I'm saying, you sure you didn't have anything? No, Gar. We do marvelously. She comes in, she does a great job on my direct exam. The opposing counsel now gets up and says, Mrs. So-and-so, were you born such and such a date? And did you live at such and such a date? And is your Social Security such and such a date? And do you remember going to Helen Hayes Hospital 30 years ago? No. Well, looking at a report, and it says that you've had a back problem for 20 years ago. Now, your testimony was basically you didn't have a problem ever. And here the report says you've had a problem 30 years ago for back problems. What is it? And the jury, one of the jurors who I was kind of friendly with, we had a rapport, and she comes over to me, she says, Mr. Lipton, I would have given you anything on the case. But that client, your client, lied to us. And I wasn't giving her 1 red cent. So you got to be careful with this, and you want to make sure that you get all the reports. I got to tell you, 30 years ago, I never anticipated that. But it happened. When you get into court, you want to know about demeanor. You want to know about your opposing counsel. You want to know about your client and defendant and all the history you can. We've talked about venue. And quite frankly, you want to know about how much is the case going to cost you to process. You want to know how much are each of the doctors going to cost. And if they're offering you $20,000 and you think the case is worth $25,000, do you really want to go in it when you know the doctor is going to charge you $5,000, $10,000, $15,000? You want to be careful on that. If somebody is over 65, what are you going to want to know about? Medicare. Why? Medicare liens. So you have to know whether there are any liens or not, because you have to indicate to your client basically that there's a lien. What other liens could be? Workers' comp. However, there's an exception. I think it's Berenson or something. There's an exception to that. Up to $50,000, no fault takes care of no fault takes care of it. Anything above $50,000, workers' comp has a lien, and you have to know what the lien is, so you can adjust. And you tell the insurance company, hey, we got to pay a certain amount of money to the on this particular case for these liens. In New York State, when I started practicing law, hospitals had liens. They no longer have liens as a result of some legislation, so that's interesting. Client comes to me and says, New York City bus hit our client in the rear, and as a result, my client got hurt. What immediately hits you? 90 days. Why? Okay, 50E and Article 50 of the General Municipal Law. You got to be real careful about that. If you don't send out a notice of claim, you probably have an extra year to make an application to, and I think it's 50I that you look towards, but you have an application that you can make to extend that period of time and ask for it. Let's assume the person is 7, 8, 9 years old. What result? Anybody? 7, 8, 9 years old?